Dear colleagues, once again, would like to remind you, if you need a simultaneous translation from English, please take your headphones.
Translation from Russian, just to take these devices that should be somewhere near the entrance. А может поднять руку тот, кто распределяет наушники? А, там они же за дверью происходят, да? А, ну все, да, сейчас.
Thank you very much.
Okay, let's start. Уважаемые друзья, большое спасибо всем, кто...
Dear friends, thank you very much to those of you who decided to visit our section dedicated to legal issues in the internet. This year, we as organizers of the Russian Forum of the Internet, we decided to make this section, these sections more specialized, dedicated to some specific topics, to be able to concentrate on this issue and to shed some light on this topic more interestingly. Well, it's not in vain that during the plenary meeting, during the lecture of Stephen Brocker, I've asked him a question about what will happen with the Internet in addition, well, alongside, while it becomes more and more like a service, something that we call utility service. And I think that this time of issues that we are going to discuss today allow us to think that regulation and governance issues will be interesting, and it will be interesting to have sections in the Internet Governance Forum, because many of you who work with Russian law, you know that even industry like electrical trade, which is a very specific type of product, there's still a lot of problems and open questions, and both on theoretical level, there's a lot of arguments and disputes around this. And what about Internet? Our section will be dedicated to issues of jurisdictions based on the principle of transborder, and some call it borderlessness of Internet. And we'd like to say that this is a really interesting topic to any lawyer, theoretician, and practitioner, and there is a big complex of questions of relations between public domain, private domain. But I want our discussion and everything that we're going to tell each other, I hope it's going to be interesting not only to lawyers. Yes, participants of the panel are people well known in legal circles. That's why we will speak legal language about legal matters, but we want to speak in such language that it should be understandable to non-lawyers. And in order to be able to understand which problems can we discuss in this matter, I can bring a lot of examples, a lot of cases related with transborderness, with the applicability of the issues of international law, Western law. And it is well known when 2 or 3 years ago, a Georgian old lady have suddenly destroyed fiber optic cable, due to which communication was broken to the state called Armenia. In the same years, there was another blocking of internet in Egypt. But this internet blocking was done in such a way so that internet was not accessible to network users in the country, but transit traffic was provided and transborder damage didn't happen. Unfortunately, we do see similar types of situations right now in our country when a favorite law was adopted about blocking the internet, due to which a number of Russian providers, for example, Rostelecom, which provides internet services to other countries, blocks sites, IP addresses, and groups of IP addresses, and by this limits the access to internet to foreign countries. So the question is, how does this comply to international obligations of the Russian Federation? And in a brief explanation, the issue of jurisdictions can be brought to the question, whose law is this and how can it be enforced? Because in most of the cases, in the offline life, this question is not raised. For example, if somebody does a hooligan action, then there's a certain procedure procedural actions are done on the basis of Russian procedural law, and this person is called to administrative or criminal prosecution, irrespectively to which nationality, because the law was broken in the territory of our country. A more difficult situation is when mechanisms of international law are involved. For example, the question when on the territory of various country, space object falls in the territory of that country, well, there is a significant damage when they fall down from the space. And on the international level, since the end of 1960s, there is a special international convention about space damage, space-caused damage. This is a transborder damage, which has to be covered according to new international law. In cases with damage in the internet, many questions are still unclear, and we would like to listen to opinions from the dear participants of our discussion. And we'd like to say that issues of jurisdictions are not special or not something too special for the internet. It is well known that practically 95% of corporate transactions, large corporate transactions on the territory of Russian Federation, everything which is related to the oil complex, big infrastructural projects, are regulated by the UK law and UK and Wales law. And this problem is really important, notwithstanding the fact that we are developing our own legislation, the civil code is being developed, but nevertheless big Russian businessmen, they prefer to solve their disputes on the basis of legislation of other jurisdictions. And this is a serious problem which is in the field of our political attention, and the answer to this problem is very simple. We have to adopt our internal good quality legislation in order to interest Russian citizens to go to the court on the basis of Russian law. So I would like to begin and would like to give floor to the speakers, and I would like to attract their attention to the issue which is, in general formula, can be formulated the following way. If organization legally created on the territory of its own country and legally doing its actions and doing the business in the territory of its country, how do they have to follow legal requirements which are provided to this company by the state, by other states against this company? This is a really important problem, a really big problem. It's not related with some violations like pornography or political censorship, but this is also a problem of online casinos, gambling. It's a problem of what we call financial markets. And active role is played by the United States of America, which actively is striving to distribute their jurisdiction to any legal relations where the citizens of the United States could be involved. And this problem also is really practical to organization which I represent, Coordination Center of Domain Name RF. And currently registration of domains are done for Russian applicants on the basis of Russian law. And in this connection, Russian law has no problem with it. We think that our legislation is regulates pretty well these issues. But when there will be hundreds, thousands of new GTLD high-level domains, which laws will regulate all the disputes that will appear in this area, and what Russian citizens should do just in case if all new domain areas like .Moscow or .Tatarstan will have initial documents about providing domains to them under the common ICANN registered in the state of California on the basis of Californian jurisdiction law. Like domain RU and RF are national property of the Russian Federation in case with RF Russian Federation. And the final thing that I would like to ask dear presenters, please ask questions of collisions, not only of legal character, because as we know in the internet, not purely legal norms are being applied. More and more often we see application of laws, which in the theory we call corporate regulation, organizational regulations, and technical regulation as well. These are difficult technical standards, RFC, how the issues of jurisdiction and level of legislation should be applied and considered in this case. So, dear colleagues, I'm really proud that I was given an honor to introduce respected participants of this discussion. We will work on the basis of the following scenario. Each of presenters will make a brief presentation, 4 to 5 minutes each, about the topic they want to speak about. Then we will have a free discussion and an interactive discussion with the participants from the hall. So I would like to ask for the discussion to be opened by a well-known French lawyer, a member of the ICANN Corporation, and my personal friend. We've been working with him in different international working groups. And please welcome Bertrand de la Chapelle.
Correctly, yes. Thank you very much, Mikhail. It's a great pleasure to be back here at the Internet Governance Forum Russia. I am leading since last year a project called Internet and Jurisdiction, so that's a reason why I'm particularly happy to see this topic being put on the agenda here. I can give you more details in a separate discussion on the project itself and its purpose. But what I want to share with you is a few things that have come up in the discussions we facilitated last year with government, civil society, and private sector on this issue of jurisdiction and the interaction with the Internet. The first thing, as the title of the session indicates, there's a common wording regarding the Internet that says it is a borderless space. This is simply not true. It is a cross-border space. And as a matter of fact, it's more than a cross-border space. It's a collection of cross-border spaces. And those spaces can be public, they can be private, they can be semi-public, semi-private. It's just like a city. You have apartments, you have shops, you have streets, you have agoras, you have stadiums. The Internet is all that, and the social networking spaces provide those different levels of privacy, semi-privacy, and openness. And the rules that apply for those different spaces naturally are different. The thing is, most of them enable, which is wonderful, the interaction of people across borders. And you naturally have as a consequence the fact that not only is the Internet not without law, it's actually with a lot of laws. It is covered and it is regulated in a certain way by a patchwork of national laws that apply according to different criteria. It can be the location of the user, it can be the location of the server, it can be the country of incorporation of the operator itself. The problem is that this patchwork of national laws is sometimes overlapping, sometimes conflicting with one another. The jurisdictions, the attribution of jurisdiction, or the decision by courts, for instance, can be completely contradictory in one country or another. And the end result is difficulties of enforceability for governments. It is legal uncertainty for the users, and it's operational challenges for the platforms, who have to develop terms of service that are supposed to be compatible with 190 national laws. So, not borderless, but cross-border, not lawless, but a patchwork of national laws. The interesting thing when you talk about jurisdiction is it directly connects with a word that I used to jokingly call the S word, which is sovereignty. And during a while, the notion of sovereignty was absolutely taboo in the environment of Internet discussions and Internet governance discussions. Fortunately, I think the landscape is clearing a little bit. And the way to understand how sovereignty plays with cyberspace, and actually how it interacts with the geography of cyberspace, is as follows. There is no way to handle policy issues without taking into account a principle of sovereignty. The principle of sovereignty exists, it is useful, and it has to be leveraged. The problem arises when we don't understand that the way sovereignty is being exercised in an interconnected environment in the digital age must be different from the way sovereignty was exercised in the 16th, 17th, 18th and 19th and 20th century. Let me clarify. The notion of sovereignty fundamentally emerged, as you probably know, from the solution of the Treaty of Westphalia in 1648. The goal was to enable a solution to the religious wars that had disturbed Europe for 30 years. And the solution was, and I insist on this point, the separation of sovereignties. It was fundamentally, this is my territory, I do what I want on my territory, this is your territory, you do what you want on your territory, and we don't mingle with one another. This is all well and fine when the interactions across borders are the exception and not the common practice. In an environment where the daily interactions for commerce, for social interaction, for publications, advertisement, and elsewhere, are fundamentally and in majority cross-border, the exercise of sovereignty and the solution for global governance on the internet cannot be the separation of those sovereignties. It is not about drawing very specific lines and saying this is mine and this is yours. And why is it so? Because one, on the internet, the exercise of national sovereignty on operators that are on your territory may have impact directly on actors who are not on your territory. Therefore, if you defend your sovereignty and you affirm it without any limits, you actually impact the sovereignty of other countries. And this is in contradiction with the very principle of equal sovereign rights of states, if you want to be absolutely truthful. Therefore, the challenge is not to separate the sovereignties, but to manage in common those new spaces that are cross borders and to find solutions for the coexistence of different sets of norms in those shared spaces. So this is about the notion of what we could call responsible sovereignty, i.e. sovereignty exercise taking into account the limits that have to be imposed on the exercise of sovereignty due to the transboundary impact that you can have on others. And Lee will certainly have the opportunity to talk about the work that the Council of Europe has done in that regard. I'm finishing by highlighting another dimension. So far we've talked about sovereignty, states, and governmental entities. One thing that is very interesting in the development of the internet, and especially the third stage after the email, internet, after the World Wide Web, we're now in something that we could call a social net, with basically shared spaces. The platforms that have developed, and Facebook, Twitter, YouTube, and others, are actually digital territories. As long as you are on the servers of Facebook or VKontakte here in Russia, you are actually under the law of those territories, i.e. the terms of service that those platforms develop. And those terms of service actually put in place something that is very close to the constitution of those digital spaces. It says what you are allowed to post or not post. It says how your account can be suspended, like your citizenship for this platform is removed. It says whether you are going to be delivered to other authorities, like your personal information is given to law enforcement agencies in case of criminal investigation, and so on. Those digital territories and the terms of service that they have developed are new forms of cross-border authorities. And the tension that is at stake at the moment is the tension between those horizontal normative rules across borders and the vertical patchwork of national jurisdictions. How do they combine? How do they coexist? Is one of the main challenges. And one of the goals of the Internet and Jurisdiction Project at the moment, and in 2013 in particular, is to help develop interactions among those actors, to identify how the interfacing between law enforcement agencies and platforms, for instance, on issues like takedowns or access to privacy data, can follow appropriate, transparent, accountable procedures that ensure that the rights of individuals are respected, but also that the system of cooperation is efficient. For those who are interested on this issue of geography of cyberspace and sovereignty, we have brought a series of copies of an article that I produced for Circle ID, and they should be near the door when you exit. I could go on for ages on this topic, but I finish here and we can talk more afterwards.
Merci. Спасибо. Спасибо, Бертрand.
Thank you very much, Bertrand. Well, in Bertrand's speech, there was names of organization that will be the next month, Hibbard, and he's well known by our colleagues who've been cooperating with the European Commission from the side of the civil society, and right now Lee together with us. So, Lee, the microphone is yours. Questions afterwards. The questions are in the end.
I work for the Council of Europe, and that also means the European Court of Human Rights in Strasbourg. And this is an organization which is multilateral. It has 47 countries as members of it, and that includes the Russian Federation. And Russia joined in 1996, and it also signed and ratified the European Convention on Human Rights. So the first article of that convention, so we're really talking about the law here in a cross-border context, is that Russia has agreed to protect or secure the rights and freedoms in that convention to all the people in its territory. So straight away there's a question of jurisdiction, of geography, and that means perhaps the geographical jurisdiction of the country. So that's the role of the Russian Federation in terms of protecting you, your right to freedom of expression, your right to private life, your right to be free in terms of assembling and associating, and that's the starting point for a lot of the work in the Council of Europe. And we work together, cross-border between countries in multilateral forums. But we do find now, with regard to the issue of the internet, that multilateral is moving to multi-stakeholder, because you really need to work it out not just in a closed room with governments. It's not so easy to do that, and it's much more fruitful to have a lot of other voices in the room. That's where we're moving to. It doesn't mean that the law will change in terms of who decides on things, but at least in terms of shaping the decisions and making sure that everyone has a voice. It's a very important step in that. And we have a piece of work in particular on a compendium of rights for internet users underway, and we have the Russian Federation in that group, talking about how to make users have their rights online. How can they exercise those rights to freedom, to privacy, etc. So it's work underway, and it's multilateral, but it's also multi-stakeholder. We also have just to start this, we also have a convention called the European Convention on Mutual Assistance in Criminal Matters, back from 1960 around about, which is used still today. So this is an internationally legally binding instrument, which is signed by all the countries, which is functioning on a daily basis, and it's working in terms of sharing information, evidence regarding different countries in terms of witnesses, etc. So law does also work in different contexts, but perhaps not in all contexts. And the internet is this challenge. So states have a job to protect. So they have a job to protect children, for example, as was mentioned earlier. That's part of their role. There's a job to protect against crime. That's also part of their role. There are cases which have been brought to the Court of Human Rights regarding a server in country A, the perpetrator in country B, and another country being involved. So it's very cross-border, question of jurisdiction. But there have been some cases which have sort of tried to deal with this cross-border issue in terms of protecting against crime, obscene pornography, for example. And so there is some attempt, although it's not fully developed. There's also a case communicated to the court now regarding the Swedish law for interception of internet traffic, regarding, I think, things to do with national security and other things. And I don't have the details of the case, of course, but it will involve private life. Certainly will involve the right to private life. So this is a cross-border issue dealt with from the perspective of a country trying to deal with national security. That's a legitimate role for the state. It becomes complicated when it crosses borders. And we have a piece of work in the Council of Europe talking about doing no harm to the internet. As Bertrand said, doing no harm to the internet means, you have the right to do things in your country, in your jurisdiction, but make sure that whatever you do in your country doesn't affect country B. So you may have that right, but you can take measures which I think can have an effect on another country in terms of things like traffic, etc. So this is something which is work in progress, but it just shows you again where the work is going to in terms of human rights. And I think when you take cases that we know in the press, things like Twitter and France, and the trend regarding, a good Jew, when you look at the question of this video clip on innocence of Muslims, you see all the colours of the rainbow in terms of how to address these issues. But what you do see, I think it's quite revealing, is you see a company not playing ball with a country and decision of a court in a country. And it just shows you the tension between a company and a country. While a country is trying to do its job to protect the morals of its citizens. I think that's very revealing in this day and age. With the internet is a lot about private sector innovation, as we said this morning. So there's a lot of conflict and there's a lot of complexity and conflicting judgments across Europe about issues regarding the internet. I think the thing I'd like to put across is that at least in a domestic sense, when we're dealing with things to do with content, when we're looking at the court, human rights, we're talking about all those issues that you've mentioned. But at least the domestic law has to be clear. It has to be very accessible, clear, narrowly circumscribed, very specifically targeting the action to be taken. It has to be foreseeable, so people know how to act in relation to that law. And if you get it wrong, which means if the law is too vague, if it's too open and it overly protects, then you can affect other content, very lawful, legitimate content. So that's the thing with regard to the convention and the court's reasoning, is how to make sure that we can, abide by, human rights procedures, getting the procedures right. So that's the key. And I think a lot has to be time spent on trying to get domestic steps right to make sure that law is accessible, clear, foreseeable. So, but I think what I'm learning is that because of all this complexity and the cross-border nature, particularly with freedom, because a lot of free flow of information, free flow of traffic, is that although governments have a margin of appreciation to protect, it's also very important to take, before acting, to be restrained, to act with a sense of responsibility, not perhaps to jump in too quickly because of all the different actors involved, and to have a light touch to the internet. That's what we're learning. To have a light touch to the internet, not to overly regulate it, to make sure that we keep the internet free and go. This is what Steve Crocker said this morning, was just taking a step back really. So the law is slow, the technology is fast. That's a challenge. So I think when we're talking about courts and lawyers, they're looking to laws which are maybe slightly in the past, when we're looking at challenges in the future. I wonder whether the lawmakers and the judges and the lawyers are sensitive enough to these trends. Okay. So when we're talking about rerouting of traffic, when we're talking about the end-to-end principle, I wonder whether we're able to cope with those new issues. It's a shared environment. There are lots of things to think about, but doing no harm to the internet, staying within your jurisdiction when you act for legitimate reasons is very key. And but getting your domestic legislation right, I think, is a very important point. So I'll stop there. Thank you.
Большое спасибо.
Thank you very much. The next speaker will be the representative of the organization which recently became into one of the leading Russian research scientific institutes in the issues of internet governance, Diplomatic Academy of the Ministry of Foreign Affairs of Russia. And I would like to give floor to my colleague, respected Madina Casanova, deputy of the International Law faculty of the Diplomatic Academy, known for her publications in the area of international legal aspects in Internet regulation. Thank you, Mikhail. Thank you, dear colleagues. There was Bertrand's presentation, and he took some things from my tongue that I wanted to speak. So I will continue to what Bertrand was speaking about and to what Hibbert was speaking, just due to the fact that the context that we see is in itself, because I was planning to speak about something else, but I would like to continue those ideas that were expressed by these two presenters, and I will build my presentation in a little different way than I wanted. Well, my thesis is a very brief one, and I would like to afterwards hear your reaction because it's also interesting to me. The question is due to the fact, the issue is connected to the following fact. If we will remember the fact that Internet is 40 years old, and that in the beginning, Internet, the ideologists and researchers of the Internet came to a certain euphoria that it's transborder space, it's a different jurisdiction where state has no relation to, and jurisdictions and sovereignty concepts, they go to the second plane, everything can do anything, but the time has shown us that this was a wrong vision of this world, and I would say incorrect, inadequate perception of this world, and just in the recent 20 years, a certain transformation happened in relation to what is jurisdiction, what is sovereignty. And it was really obvious that national law is necessary, domestic law is necessary, because it also will govern those relations which happen in the Internet, equally as on the Internet, as international law is necessary, because by the means of international law, you can solve those issues which are related with transjurisdictional character. If we're going to speak in general plane, what is a jurisdiction? Is an action of an authority on a certain territory for a certain circle of entities, aspect number one. Aspect number two, it's a possibility to go to the court in that or another country about various facts. And number three, it's a possibility to admit and to execute, enforce those decisions made by courts which were decided in one single jurisdiction and could be transferred to another jurisdiction. But in any case, we can speak about something that Internet has not changed the necessity to influence public relations in this particular context. Respectively, what are we speaking about? We're speaking about the fact that Internet became reality of our life. In this case, we speak that currently on the level of law there is a need for harmonization of national legislations. Why? Because Internet, as it was discovered, is a self-regulating space in the context that Internet management can be fragmented in a framework of various borders, sovereign borders. And we can see some examples that Internet, which exists in America, it's one context. Internet which works in China, it's totally different context. Internet which acts in Palestine, Syria, it's context number three. So the composition of the network shows us that fragmentation of legal regulation in the framework of various sovereignty or jurisdiction is possible. And then afterwards we have a question, if in this particular context we will see a development of legal enforcement on these relations, then there will be a danger to destroy some unity. But in principle, Internet is as it is, and the self-regulation will balance these approaches as well. Then afterwards we see that we undoubtedly will face the situation that there is only mechanism, or maybe one of the mechanisms of finding the common points is based on the international law. What is an international law? It involves international organizations and international agreements, and practically what Mr. Lee was speaking about is a witness of the fact that that convention about human rights that was adopted and ratified, in itself, it had a mechanism of realization of conditional norms, possibly to solve issues of jurisdictions and cooperation. Well, perhaps we can use the mechanism of international agreements, but for international lawyers, it's also obvious that making some kind of a single international agreement which would cover all the issues of Internet, it's impossible to make some. So, as one of my main conclusions, because we need to be brief, well, I would like to say it in the following way. A long time ago, when we just seen the first airplanes flying in the air, states faced a question to the fact that the state over which the airplane is flying, does it fulfill the sovereign rights of its sovereign airspace? The answer was yes, but the Internet gives us other questions. What is a territory of a state? The airplane, or let's not speak about airplanes, that particular vessel that swims in the sea, and a person which uses internet at that moment of time, and he has his certain flag. Is it a territory of the state, this ship or airplane, and can the state execute its jurisdiction on that territory? These are obvious questions which will happen, and they are discussed in the framework of the context of the international law as well. And in any case, I think that as a generalization, I can say that if we will come to the question of jurisdictions in the internet, we undoubtedly will face two main, I don't know which word can be used, we face the necessity that we still deal with national domestic law. We still are bound by the factor of harmonization and regulation of relations, and it's unavoidable. Harmonization of national legislation should happen. On the other side, it's a question that it's still necessary to look for some new ways for cooperation in the context of international agreements, just with the purpose to create some conventional unificational approaches which would simplify our interrelations. In any case, I think it's better to agree than to argue. Thank you very much. Thank you, Madina. I would like to give floor to a well-known specialist in the issue of jurisdiction. Those lawyers, including Russian lawyers, who are involved in this particular problem, they are well aware about works of Konstantinos, and I would like to give him a floor with a purpose. Konstantinos Komaitis, my apologies. He represents organization ISOC, which is one of the most nuclear in a system of internet governance, the development of the internet. What is the point of view of this organization, and what is the point of view of Konstantinos himself?
Thank you very much, Mikhail, and hello everybody. I am very happy to be here, and thank you for the kind invitation. I will be switching hats between my previous academic job and right now as a policy advisor for the Internet Society. I have spent a good part of my academic and research life dealing with exactly what we have been discussing so far and what this panel is all about, and I will not be repeating a lot of things that my previous panelists have already spoken about, but let's take a step back. Jurisdictional conflicts are not new. Even before the internet, states and courts had to deal with jurisdictional questions, and case law is replete with examples where the laws of one state might be imposed on another state, which always then led to the creation of bilateral agreements, even the drafting of treaties. However, with the internet, what has changed in those jurisdictional conflicts is the quality and the quantity. Every day, almost every day, there is a jurisdictional issue that needs to be addressed in the context of the internet. And there are plenty of examples. I mean, we have it in the case of domain names, for example. We see that there was back in 1999 a piece of American legislation that even up until now influences the way generic top-level domain names are being handled. We see it in the context of e-commerce. Bertrand made the point. You have multiple jurisdictions at play at the same time. You might be a user in Russia. The company that you're buying the product from might be located in Argentina, and the servers might be in 2-3 places around the world. We see it also, especially in the context of intellectual property, and there, if you want, things are becoming even trickier, because if laws are national, intellectual property laws obey first and foremost to very specific principles of territoriality. So there is always this question in the context of copyright, which law should prevail, why should it be that law over the other, etc. And lately, we see it also in the context of cloud computing. We see legislation that has nothing to do with cloud computing, and I'm referring, for example, to CISPA, which is in the process of becoming a law. And no matter what you believe about that law, there are some questions that have been raised in the context of privacy. Now, considering that a lot of those cloud service providers are located in the United States, inevitably that law might influence me that I'm using one of them as a hosting service. So, throughout, if you want, the jurisdictional history, states have come up with various tools in order to address those jurisdictional problems. So, for example, we have seen the jurisdiction to prescribe, and I am becoming a little bit too legal here, but this is a basic principle within jurisdiction that allows, to a certain extent, a state to apply its laws extraterritorially. So, ever since the internet became commercial back in 1996, there are two schools of thought relating to jurisdiction. One of them says that we don't have a problem, that public international law, the way it has been working before the internet, is able to provide solutions. The other school of thought says that we actually need to come up with new laws for cyberspace because the issues that are emerging are so unique that public international law is not able to offer any viable solutions. This debate has not really come up with a concrete answer. Both, as far as I'm concerned, both have very good arguments to make. But what is becoming more and more apparent throughout this, if you want, very brief history of the commercial internet is that one way to address a lot of these issues is through by employing some tools. And what we mean by these tools, first of all, we came up with the multi-stakeholder model. So right now, policymaking is not vested just upon governments. It is the uniqueness and the advantage of the multi-stakeholder model is the fact that information is being exchanged. Thus, it can lead easily to best practices, where countries can actually take advantage of this platform to exchange views concerning national laws, what has been working and what has not been working. Another tool is to look at technology. A lot of the answers that policymakers are struggling with and lawmakers are struggling with and create all these jurisdictional headaches can be resolved, or there is an attempt, better yet, to be resolved through technology. So the Internet Engineering Task Force, at their latest meeting, they had a very interesting discussion as to whether technology can create, we can use the layers of technology, the layers of the internet technology, in order to give the possibility to the creator of the content to identify his or her intention. I want my content to be free. I want it to be licensed under this licensing scheme. I want to make a lot of money out of my content. So basically using technology and employing technological measures to be able and find solutions. And finally, and that was mentioned, there is the issue of self-regulation that we see emerging more and more because one of the advantages that it has is that it really corresponds to the Internet's character, which is the speed, the easiness, and it is able to address in much speedier way and without the jurisdictional conflicts the various issues. Now, all these tools, of course, are not providing solutions. The solutions, I think that it's very early actually to even talk about solutions. What we possibly might want to do is start a mapping exercise. There is not one size fits all here. We cannot say that this is what we're going to employ to solve all the jurisdictional issues that exist right now. So a mapping exercise of identifying where public international law can offer solutions, where self-regulation can offer better solutions, might be a very good start. And just to finish, because there has been a lot of talk, especially in the context of jurisdictions, about governments and sovereignty. We've heard the issue of sovereignty. governments have a responsibility, and we need to understand that. They have a responsibility against their citizens, they have a responsibility towards history, which is the ultimate arbiter, if you want, of their governance schemes. But they also have a responsibility towards the internet. And that responsibility is to make sure that the internet continues to operate in the way that it was created, based on democratic and open standards, and also to make sure that it is global, that it continues to function as a global pool whereby everybody is exchanging information and everybody is able to reap the benefits of the internet. And I will stop here and pass the floor. Thank you.
Спасибо, Konstantinos.
Thank you, Konstantinos. And I would like to give floor to the specialist who worked in our ministry in governance authority. She worked in largest Russian internet companies. And she's one of the leading specialists in the area of security and cyber crime. Uliana Zinina currently represents corporation Microsoft, a well-known transnational corporation in whose activities there's a big number of issues of jurisdictions, applicability of foreign law. Welcome. Thank you, Mikhail. Hello, dear colleagues. It is very difficult to speak after such generally theoretical issues that were raised by previous speakers. And I can just join this common conclusion that issue of jurisdiction is a complex problem which has no solution today, and we're still in the beginning of our way, especially in Russia, in searching approaches to solving this problem. And I, for myself, would finish our panel by a more specific example in relation to which we face problems of jurisdictions, and namely cloud computing, what Konstantinos was speaking just before me. Because cloud computing, it's a classical example of a very complex service where the problems of jurisdictions play a significant role to a wide consumption of those services. And the problem of jurisdictions appears in two main aspects in relation to cloud computing: private legal aspects and public domain aspects. Private aspects is a selection of the agreement, model, and applicable law to relations between parties. Of course, currently there are no peculiarities for cloud computing technologies from the point of view of applicable law, and parties are free to select this applicable law on the basis of general principles of international private law. And well, perhaps except for those issues which have some particular specifics, like e-trade. In addition to that, in application to cloud computing, there's another peculiarity related to the technology of providing cloud services. The fact that very often many people saying that in the agreements between clients and executors, there should be application of a law where the client's data is being stored, but at the same time, many people forget that cloud computing very often is related with distributed storage of data, and client's data may be stored in different servers, in different countries, and in different volumes. Therefore, from the point of view of common sense and from the point of view of European approaches, it's not always possible to look at the country where the data is stored as the country of the main jurisdiction, as the country which jurisdiction will be applied to the agreement between parties involved. At the same time, we should take in consideration the fact that it's not always the applicable law covers all the risks of cloud service, cloud computing services provisioning, because there's a second moment, which I was speaking about before, is a public domain relations related to cloud computing as such. And namely, main issues related with personal data processing in the cloud, which is always related to transborder transfer, also cybercrime, and also procedural rules of investigation, and the law of which country could be applied in those cases is still a big question mark. And if speaking about applicable law, or an example of selecting of applicable law in Europe, then European Directive on Protection of Private Data tells us that in case of personal data processing in Europe, they apply the law of that European country and territory of which the main equipment of executing company is located. But in our country, we don't have such rules yet, and we still will have to develop such approaches. What about cybercrime? In application to Russian Federation, main principles are based in the criminal code, application of the criminal code about territories and circle of entities involved. But also would like to agree to Konstantinos about the fact that for public domain relations, perhaps we should think about some international tools in application different areas like private data, computer crime, cybercrime, and others, which would define the main criteria of choosing the applicable law, applicable jurisdiction, on basis of which member states will develop their own domestic legislations in order to avoid the situation when, specific example, initiatives of the state parliament in Russia in the law about the internet, they would like to adopt specific norms and jurisdictions. That's what it says in jurisdictions, that, for example, they apply the law of the Russian Federation in all cases if the access to the internet happened in the Russian Federation. But we can argue about it, and we can make numerous examples and arguments against such criteria. Therefore, I think that in relation to these laws, public domain relations, we have to think deeper about developing international tools. Well, on this I would like to complete my speech, and maybe we can continue as a discussion and a Q&A session. Well, thank you very much. Thank you all very much for your small speeches. And I would like to make a resume of what we heard. We heard a lot of interesting things which extend very narrow concept of jurisdiction to a full set of problems, and not aspects of those were verbalized, but nevertheless we did hear, and I'm really thankful to Lee for that, an idea that even in questions like international public law, international private law, if we're speaking about relations related with the internet, they should also follow the multi-stakeholding basis, because in all these questions we still need to have a joint participation of us, public state officials, diplomats, and business community, including Russian business community and business which operates in Russia, and our civil society, in order so that those decisions that will be selected would answer the demands of all of them. I also would like to pay attention, like Bertrand said, to the problem of jurisdiction. Well, it is connected to the problem of sovereignty. It is very important because until current days, our official state representatives on the international level, especially everything which was related to the internet governments, they have been calling only international sovereignty domination if the decisions are made in Russia, so that this sovereignty has to be adopted on the international level. Well, at least we have a lot of things to speak about, and there's a lot of things to agree about, and to find some theoretical points of justifications to adopt various decisions. Also, it is very important to look in the dimension of jurisdictions as human rights, and what European Commission is doing, European Council is doing, because in the beginning there was a commonly accepted position that everybody is a sovereign on the territory of his sovereign country, and he has a right to do whatever he wants to do, before the human rights issues were raised, which finally came to the question, has the sovereign right to stop internal violations, to prevent like mass destruction weapon, well, on the basis of older concepts about sovereignty, then perhaps yes, anybody who is sovereign in his own territory, he can do whatever he wants, but this violates human rights, and examples related with Iraq, with application of chemical weapons on the territory of their country, not in military conflict, not in an intergovernmental conflict, in principle is being judged by the international law. I think similar analogies will have to be formulated and fixed and applied towards the internet. How is it applicable for protection of the political regime of various countries to execute large-scale measures to block the internet on internal territories, and how does it comply to international agreements, or how does it contradict to them? And as a practical example, the issues of jurisdiction, I think that more and more from year to year, cloud computing will become that topic that will constantly raise those questions, and we'll have to solve them on a practical basis. So right now I'd like to listen to some questions or brief comments from the audience, so that maybe we could clear some questions or maybe specify some questions. So welcome. Please, first of all, speak into the microphone, and second of all, introduce yourself. Speak only in the microphone, so that this will be translated. Your questions will be translated, and this will be also recorded as well. I'm from Diplomatic Academy in the area of IT security and IT technologies. Professor Strakov. Well, I had another question. We're speaking about creating of something, but before we can create something in somebody's head or in so many heads, they should create a model. Nobody have cancelled brains, so in the beginning we should create certain tools, and with these tools we should create certain model, but by creating model we always should have a final objective, otherwise we will close the black holes, which will appear and appear once and once again. So we will solve problems while they will appear, and this is not the right approach, even though it might be right. The word right is not the right term, because following or non-following the law, and before we don't have laws, we cannot say that internet, which was developed as a free community of free entities, is wrong. There is no right and wrong, because there is no right or wrong in this limitation, and I was perceiving that in the beginning before you have asked me. So what is your question? My question is about, is there anywhere a concept of what should be developed for the international community? Has it been written on a paper, or, and who is the person you're asking this question to? It's a general question. Who can answer it? So in the beginning I would like to say that there is a law, and there's a lot of laws. For example, the Russian law, which I really respect, the law about prohibition of the gambling business. The law is enacted. It limits the gambling business by 4 territories in our country and prohibits these type of activities in the internet. Is it followed in the internet by all other countries and participants and users of the internet? The answer is not. What is the end objective? The end objective was different. But the question is that laws, they do exist, and the fact is they have to be followed and enforced on the international level. Maybe anybody of the speakers wants to comment to the comment of our colleague. Bertrand?
A very interesting question, which is, what are the problems that we're trying to solve, and what are the mechanisms to solve them? One of the fundamental overarching challenge and objectives, in my view, is to find frameworks that enable the coexistence of very different norms, principles, practices, and cultural references in shared spaces online. We have communities now of 2 billion, 2.5 billion, 3 billion, 4 billion. And to make a long story short, I believe that history is basically the continuous effort of mankind to organize itself in entities that are larger and larger and larger and larger. You had tribes of 20 people, 100 people, thousands, tens of thousands. We now have nation states that oscillate between a couple of million, not to mention small islands, and a couple of 100 millions. We now have a challenge, which is how do we organize the coexistence of people in scales of 1, 2, 3, 4 billion. So that's the ultimate goal. The second element of response is, in terms of model, the model is a process rather than an architecture. It's the starting point of getting the different stakeholders around the table on an issue-by-issue basis. And in this respect, instead of trying to think about one single overarching treaty of regime for everything related to the internet, it's to continue the practice that has been followed until now of developing an ecosystem of regimes and institutions that each deal with different types of things, because the stakeholders are not the same for spam as they are for copyright issues, and some overlap, but some don't. So it's a process, and the overall goal is coexistence of different norms, I think.
Спасибо. Thank you. Madina?
Yes, I would like to, if I may, to generally answer your question. Basically speaking, this question of modeling what is to be done was raised long time ago, and beginning with the year 2003, when there was a first meeting on the top level on the issues of informational society, and when people were gathered together and have developed the concept, what is the internet direction? The second stage, which basically speaking was invented, or as it is called, Tunis program and plan of actions, and what humanity is moving towards the third stage, how can I say it? Third meeting at a high level in the year 2014. Basically, it's the conservative of the global community, what is to be done, and which models are possible, basically speaking. So there is a developed Russian legislation. There is a big number of acts which work in different countries which are dedicated to the issues of internet, and I think it would be incorrect to say that there is no laws. Laws, they do exist. They are different, basically speaking. The issue right now is related to the fact that if we raise an issue about governance in the internet, basically speaking, this issue was never removed from the agenda, and the fact is that the key point or the main question of the internet governance today is concentrated in which model has to be selected. Should we select a model of existing international organizations, and should we pull it into this area, the ICANN's competencies, or should we leave everything as is? But in any case, this functioning and further development of this model, which is called multi-stakeholderism, and understanding by the state, and finding by the state of its own place in this picture, and modeling is possible only when all the stakeholders which are included in this process will understand their role and their place. And this is a question of modeling. My apologies. Speak into the microphone. Well, my apology. I think this is not a specific question. You're absolutely right in relation that it's incorrect to say what is right and what is wrong. Yes, of course, there is nobody who will reject your statement that you're right. You are right. Lee?
I mean, for me, my context, there is an end objective, and that's to protect human rights and freedoms, and that is the ultimate goal. And wherever you find yourself, if you find that your rights are being violated, there will be a choice of law which is found, and there will be a chance for you to come to the European Court of Human Rights, and that to be rectified. It might be difficult because then it involves a state-to-state relation, for example, but there will be an end goal, and that is to protect your rights. Now, there's just one thing, which is there are small steps to get there, and I think in terms of the tools that you're referring to, I think it's about designing a framework for non-interference, and I think it's trying to, as I said, try to narrow the differences between national law. I think those are two steps towards protecting human rights online.
Спасибо. Konstantinos?
Yes, very. Very briefly, I really like the angle of what is the final objective when we're creating laws, and from where I am sitting, at least, the final objective should be to preserve the health of the Internet and to preserve the Internet operating the way it has been operating for the past 20 years, because it is because of this architecture and this intelligent design that we, all of us, are able to use it, and we're able to take advantage and, experience the advantages that it has to offer. Thanks.
Спасибо.
Thank you. Wolfgang.
Thank you very much. My name is Bertrand Kleinwächter. I'm from the University of Aarhus, and my question goes to Madina Casanova. The Russian government introduced in the ITU conference in Dubai, the World Conference on International Telecommunication, the concept of a national internet segment. So this has created some confusion, and because we have the global internet, and the question of the national intersegment has raised question of the fragmentation of the internet. So it was not a clear definition, it was not adopted, but it has triggered a lot of discussion. For instance, if a Russian citizen register with a German registrar the domain name ivan.com, is this part of the national internet segment? What is the German registrar, American registry, and how, the German registrar and the American registry is then affected by Russian legislation? So I would be thankful for a clarification of this concept. Thank you.
I'm afraid that I doubtfully will answer this question because, first of all, I present myself as a person, but I can say, I cannot directly answer your question, but we have very big difficulties related with the following problem. You understand that there is a thing which is called we'll never Duralex. The law is tough, but it's the law. Duralex, setlex. The law is tough, but it's the law. But the question is that because legal regulation of the internet relations in our jurisdiction was not completed, I cannot answer your question, why is it done this way and not the other way? I have no answer to this question. But, Madina, let's not spend our time. There is an answer. Madina, I would like to say, this year, other concepts were developed how to regulate internet in Russia, but these are just concepts. And I would like to say that the word national segment was removed from this concept because they have admitted that this is anti-scientific statement. In reality, it doesn't exist, and they will never appear. This will never appear in this concept. Bertrand?
I like to make an analogy, as people who know me, I'm pretty fond of historic parallels and things like that. What is at stake is domains of validity of the different regimes. And I want to make a parallel here with physics. In the daily life, if I drop this pen, I still use good old Newtonian physics. I don't need anything else. But if I throw this pen very, very quickly to the speed of light, I need relativity, and if I want to look at how it is at the atomic level, I need quantum physics. It's not like a Copernican revolution that one paradigm replaces the other. It's a coexistence and an extension of different principles. You have quantum physics, you have Newtonian physics, and you have relativity. When we're talking about jurisdiction, it's the same that is happening. We had a very nice system where jurisdiction is entirely territorial. What is happening now, as the example that Wolfgang was taken, is that there are things that are completely territorial. Very easily, if you get a Frenchman insulting another Frenchman on a French platform, they both live in France and it's in French, and the platform is in French, of course it's the national sovereign law and French authorities. If, on the other hand, I'm traveling in Quito, Ecuador, there's an Australian that is using an American platform to do something against me while he's traveling in Italy, the definition of what is the applicable jurisdiction and the courts that I can go to is a little bit more fuzzy. And so we need to have maybe a principle of relativity and co-implementation of different laws in some cases. But the reverse is exactly true as well, because as Wolfgang said, one of the biggest challenges is when we talk about national segments, is that whenever a national authority takes whatever decision on an operator that is based on its territory, it may very well impact actors outside of this territory, leading to an extraterritorial extension of sovereignty that, to be honest, favors very strongly the countries who have the most operators on their soil. So to put it in very blunt words, be wary about what you ask for. If you jump on your chair and say sovereignty, 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 the end result is that it favors the countries that have the most operators on their soil, i.e., in this case, largely the United States, China, and a few others. So sovereignty has to be shared and taken into account the impact that it has cross-border. So the notion of segment certainly cannot be bounded by a very precise limit, and this is probably the reason why the expression itself is not easy to maintain. I don't think it's a very operational tool at this moment, and reterritorialization is clearly not the solution to the jurisdictional problem.
Спасибо. Madina, пару слов, пожалуйста.
Да, если можно, я отвечу.
If I may, I would like to answer. I will try to answer on a couple of examples, if it is possible. Be closer to the microphone. What did I mean when I've said about fragmentation? It is a well-known example. Well, when many years ago through eBay, you could buy any product, including with Nazi symbolics. In France, there was a law which strictly prohibited the turnover of products with fascist Nazi symbolics. And of course, in the jurisdiction of France, it was impossible to buy products through eBay with fascist Nazi symbolics. One example. Another example which could also clear what did I mean by that. 2 years ago, the group, the law about defamation that was selected, it was decriminalized, actually, this law on defamation, and it was in private legal tradition, private legal aspect. 1 year ago, or 6 months ago even, the composition of a lie was criminalized again, the defamation or lie. So then we have a question in which jurisdiction we exist, and when defamation in one jurisdiction is a civil delict and in another jurisdiction is a criminally prosecuted action. So that's what I was speaking about. My apology, I will give you a floor. Thank you very much. I have 2 questions. You've mentioned about possible harmonization of legislations between different countries, which could improve the situation. But how do you perceive which process could be invented in order to make this harmonization really happen? Is there
оптимальной для того, чтобы подобного рода движение происходило? Konstantinos, пожалуйста.
Very briefly, I cannot say which platform, but I can say which platform cannot be the place for such harmonization. And at least under the way these platforms have been operating for many, many years, international intergovernmental organizations and treaty-making bodies are not the best solution right now. And they're not the best solution because they have to go through their own arduous and very bureaucratic processes. The internet moves with the speed of a light. If law is slow at a national level, you can imagine what's happening at an international level. So, for example, treaties are being negotiated for 14 years that talk about harmonization. In 40 years' time, what the international community might be sitting down discussing will be completely irrelevant in terms of internet. So I think that we have done a very, very good start with the multi-stakeholder model. And why this is a very good start, it is because, again, and I will be repeating myself, it is the exchange of information, knowledge, and know-how that ultimately will give solutions. So what is happening in one state, the private sector participating and having to deal with the everyday problems can go to the other states when they're establishing their branch offices and actually talk to governments. Or governments can talk to other governments, they can talk to other actors. So there needs to be this exchange of information because the internet is not about one thing. It has the technical bits, it has the business bits, it has the government bits, and we cannot detach all these bits from one another. Thanks.
Спасибо. Ли, потом Мадина.
Just very quickly to say that there's one very good example of the tensions. I mean, I think there's no silver bullets to these issues. There's no one final answer. I think that's where we are. But I mean, the question of privacy and protection of personal data is a very big issue, particularly in the US and Europe. And the level of protection is the big question when you have companies in the US which are basically determining the level of privacy, for example, with regard to people in Europe, which may be a different level or what's expected, and it's not, and it's being worked out now. But now,
so what? Where is the platform where such issues should be solved?
Well, the platform for privacy, I think, at least in my opinion, is in negotiations between the US and Europe.
And Russia and China?
Well, I very much hope so, but I mean, the fact is that, I mean, it's just an example of the fact is they're trying to work out the level of protection in one context, and it's not easy.
Okay.
Можно я отвечу? Я так понимаю, что
And I would like to answer. I think this is some kind of a provocation. It's a provocative question. The fact is, if you raise your question in such a way, it means that I absolutely agree to my colleagues, because if we raise the question this way, it means that there is a certain center. There could not be center, because I think this model that was created, multi-stakeholdering, no matter how it sounds awful in Russian, but nevertheless, this is a platform which is decentralized, and everybody should build on this platform, whether it's state, whether it's government, whether it's private sector, whether it's business. They have to understand their role, and we have to clearly understand where's the public sphere, where's the private sphere. But I think that if we will look behind my back, and if it says Russian IGF, I think this is an adequate platform. Basically speaking, just IGF. Thank you. The floor to Ukrainian guest, Oksana Prihoska, Ukrainian Media Platform. Mikhail, I have a question to you. You've been a work member under UN on the Internet Management. You are the member of the expert groups in the European Committee. You work in ICANN very actively. So from your point of view, from the point of view of the discussion of the sovereignty and transborder relations, the role of non-English speaking terminology, how big is it from your point of view when in Los Angeles, in Strasbourg, in Geneva, in Kiev, in Moscow, they discuss practically the same topics? People speak about the same, or they speak about different things? Thank you very much. It's a very interesting linguistic question, because if we speak about the Transborder Internet Working Group, then its top manager was a German who sits in front of us. His deputy was me, Russian guy, and a member was a French person who sits next to us. And we all are not English-speaking people, even though we have perfectly understood each other while speaking English. At the same time, There's a number of issues and a number of terms which are well understandable by English speakers, but which are difficult to translate to other languages. Multi-stakeholderism term or internet governance, these are out of those terms which are almost impossible to adequately translate to Russian, Spanish, French, German, Ukrainian, Polish, almost impossible. Therefore, unfortunately, we see, or we perhaps have to continue speaking English, calling those words as they're called in English, but at the same time we have to clearly define to ourselves in our own languages, Russian or Ukrainian, German and other languages, what is meant by those terms, because sometimes we will have to discuss it, we have to chew it in order to come to a common opinion. But I think Wolfgang and Bertrand, I think that we understand each other, right?
Ваш вопрос, пожалуйста.
Can I? I think this is such an important question. Thank you very much for raising. It's extremely important question because the question of definitions, it's not only a question of concepts, it's a question of the content. And we have Uliana sitting here when she was singing in the end, but Uliana, she's a wonderful specialist in the issues of Budapest Convention. And let's imagine that the convention is called the Convention about Cybercrime. We are not stakeholders of this convention, but in our space, cyberspace or cybercrime are translated as informational security and informational crime in the area of information. You understand? By content, by composition, it totally changes the context. And then when we start reading many of these different things in Russian language, we come to a question. In recent years, in the last 4 to 5 years, big number of strategies were developed for cybersecurity. And then we have a question, if countries will adopt this convention or this strategy about cybersecurity, and we speak about cybersecurity in Russian reality, Russian translation in our heads, we receive documents and says concept of informational security. That's how it's translated in Russian. And then it happens that we have another question. We understand each other. And do we understand each other? Where do we understand each other? In our native land or on a platform of international organizations? Thank you. We have time for 2 more questions. Can you please give the microphone to the first row? To the first row, please. Where's the microphone? Got lost. Let's give it to a person who was the first in the queue. I would like to ask a question about the gambling business. I'm not involved in gambling. The question is about the following. Every time when I open my windows from Internet Explorer, I see advertisement which tries to involve me in gambling business. Definitely. In Moscow, gambling business is prohibited. I think it would be properly to transfer this information to a Microsoft representative sitting here. The biggest monopoly in the world cognitively gives me advertising of the cyber gambling. Uliana, do you have something to answer this? Or you will leave it without an answer? Yeah, we'll stop crying right now. The final sentence about violation of Russian legislation. Microsoft does not violate Russian legislation. And I think that you could have penetration of some malware. So she is asking, is your software licensed or not? No, what I'm trying to say is that various malware products, they are widely distributed in the internet. To the internet, you can easily be, if you don't use means of security, you can get. If you don't speak into the microphone, well, let's ask questions about the topic of our section. Lena, welcome. speak. It's not a question, to Bertrand and Konstantinos, because a round table is dedicated to the question of jurisdiction, and Bertrand told us about some even historical things about development of sovereignty. Then he has admitted to the fact that the concept of sovereignty goes through a transformation, even qualitative transformation, right? And also Bertrand was saying, if I properly understood him, about multilateral model of the internet, but from legal point of view, how will it look like? And I didn't hear the emphasis on the sovereignty. So I have a question: how we will see the balance in the multilateral model of governance of the internet, development of state sovereignty? How will it be developed? And can you give the microphone to the right flank? Bertrand and Konstantinos.
There's a very simple element regarding the role of national governments in international internet governance. National governments are absolutely legitimate, indispensable local authorities at the global level. It's a very interesting question. The collection of national interests does not, in itself and alone, represent and constitute the global public interest. Just like at the national level, Russian Federation is a federation. As far as I know, no country in the world, including those who are federations, compose the national level entities like the parliament with just representatives of the sub-entities. Sometimes you have a senate, but usually you have a parliament with deputies and people who represent the whole of the country. In France, you have circumscriptions that send deputies, but we have sub-levels, but we don't compose the parliament, or any other entities for that matter, with just delegates from the sub-entities, the regional parts of France. At the international level is the same, which means that the governments and the participation in the Governmental Advisory Committee in ICANN is a perfect example. The Governmental Advisory Committee is not an oversight body of ICANN. It's one of the components of the expressions of specific interest, i.e. the collection of the national interest. And it contributes, like the other actors, to the expression of the global public interest. We may or may not be aligned with the individual national interest. To give you a very concrete example, there is, in environmental spaces, a national immediate public interest of not being constrained by regulations that limit your capacity to grow. That was the debate in Copenhagen with China and others. Your national interest is not to be constrained by cap carbon reductions and so on. However, the global public interest is that every country needs to participate in such a thing. And if you leave governments alone to discuss those things, the collection of national interest is not bringing, per se, the international global public interest. So the answer is there are indispensable parts of the definition of the global public interest, but as local, legitimate authorities at the global level.
Спасибо. Konstantinos, as short as possible, please.
Thank you. Thanks for the question. I think that I don't think that anybody's asking governments to give up their sovereignty. I think that what the governments are being faced with is to change their modus operandi of the way they were conducting things. And this, again, is very limited when it comes to the internet. We're not saying, you know, just forget everything you know about sovereignty when it comes to other issues. But when it comes to the internet, going back also to what Bertrand was saying, there is this need for cooperation. And this need is getting more pressuring. So, for example, outside the internet, you had the government sitting and deciding to come up with treaties. Right now, the issues that are appearing are so fast and they're so pressuring that this need for cooperation is becoming more intense. So going back to actually to the gentleman's question, the first question, I think that once you set as a goal that whatever we do, we need to protect the internet and we need to make sure that it functions the way it does, then the issue of sovereignty is becoming less of a challenge because you have the ultimate goal and then you try to circumscribe around it your own persuasions and propositions in order to be able and address the various and very difficult jurisdictional questions that appear.
Спасибо. Пожалуйста. Последний вопрос. Представьтесь, пожалуйста.
Общество интернета Армении. У меня вопрос очень конкретный.
Internet Society of Armenia. I have a specific question related to jurisdiction in the area of Internet. Well, we have adopted the decision, the precision UDRP, and arbitration in iPod. But we have specific cases when registered domain names and a decision about them in IPO to transfer these domain to a specific owner of the name. But we often face the situation that we cannot enforce this decision made by IPO. So I have a question. Are there any international transborder obligations which allow national courts or national arbitrations to make decision and accept the IPO's decision and enforce it? Well, thank you very much. Perhaps I will express. Unfortunately, nothing like that exists, and perhaps this is one of those directions of our general development that we have to move in. Dear colleagues, we have used the time that was given for our section, and I would like each one of the participants to say a final word about what he or she thinks about jurisdictional problems, how they will solve in 5 years from now. But because we don't have time for everyone, so I would like to ask everybody who participated in our section and participants from the side of the speakers, what do you think? We had big problems related to external trade regulation, which initially have appeared, but right now they are almost solved, and there are Incoterms, there are certain traditions, and external trade. We don't have any problems with external trade right now. Everything is developing very fast. So what do you think? And I would like to ask you to raise hands. Those of you who think that in 5 years we will finally move and big problems with jurisdictions will be solved. And then I would like to ask those to raise hands who think that even in 5 years we still will be at the same level as today. So please, let's vote. Those of you who think that in 5 years we will be able to make a big step forward. Who believes that? Thank you. And now those of you who think that in 5 years, unfortunately, we'll still have a lot of problems, and majority once again. Well, it means that even in 5 years, we still will have some topics to discuss. Thank you very much. See you next year. We start our discussion.